We will go on the record in the matter 25 CV 37, Anytime Restoration, Inc. versus Ruth Anderson et al. Appearances are, we have appearing by video conferencing, Jack et al., plaintiff's attorney. And who do we have appearing here today?
Good morning, Your Honor. Christopher Grecian, formerly of Helmuth and Johnson, currently with Parker Daniels Keyboard.
Thank you.
Good morning, Your Honor. Anthony Gabor on behalf of Ruth and Dwight Anderson. Seated to my right is Ruth Anderson. Fortunately, Dwight couldn't make it. He's in hospice at this time, so he's not here. Seated behind me is attorney Nate Allen. Mr. Allen is licensed in Wisconsin, and so he is present per the rules as I'm admitted pro hoc BJ.
All right, thank you. I appreciate your formality. Nice to have attorneys who do that. All right, so we're here today. We had a couple motions that were filed, a motion for sanctions, as well as a motion for partial dismissal. However, that has now been withdrawn. So I believe we are only here on the motion for sanctions. Is that correct?
That's correct, Your Honor.
Okay. All right, and the motion was filed by Anthony Gaber. I have reviewed the documents and read the documents, but I would like to hear argument and if you want to provide any other information. So you may begin.
Thank you, Your Honor. Do you prefer that I stand or?
You can be seated by it, but I do appreciate that. Thank you.
Okay. Thank you, Your Honor. As you indicated, we're here on the defendant's motion for sanctions. And so what we are seeking today, Your Honor, is for this court to dismiss Anytime Restoration's claims against my clients, as well as award them attorney's fees for this entire action, and to sanction the attorney and the law firm that brought this action. Because this, we shouldn't be here, Your Honor. This action was brought after many months, actually, after a fire that happened at my client's home in Grantsburg, Wisconsin, September 24th, 2024. And I've sort of laid out in the motion papers, Your Honor, how Anytime Restoration got involved. But here's what's the important thing. A motion for sanctions, Your Honor, can be granted under a number of situations. Unnecessary harassment, frivolous and unwarranted lawsuit that does not comport with existing law, and if the lawsuit is unsupported by the evidence and demonstrates a failure to conduct a reasonable inquiry. We have all three of these here, Your Honor. The timeline here is important. The complaint that was filed on April 11th, 2025. By that date, Anytime Restoration was already on notice of the fact that the emergency work authorization contract that my client signed 2 days after the fire on the 26th of September violated Wisconsin law. And the reason why it violated Wisconsin law is it is what's considered a consumer approval transaction pursuant to Wisconsin statute 423-201. And the reason it is a consumer approval transaction was it was initiated by a telephone call from Anytime Restoration to my client, Ruth Anderson. And because it's a consumer approval transaction, it is required under Minnesota law to contain language informing my clients of their right to cancel the contract within 3 days, midnight on the third day. The contract is part of the filing, so Your Honor can see that there is no language anywhere in that contract notifying my clients of their right to cancel. So there were a lot of discussions that went on once I became involved, emails and telephone calls, but here's the important part. As of April 11th, Anytime Restoration and its counsel knew the following, because on March 27th, I wrote to Mr. Grecian. And I told him that a former Anytime employee, Daniel Lip, had learned about the fire from a friend. Now, in the letter, I didn't identify the friend, but later on, we find out that's John Campbell. And this friend suggested to Mr. Lip that he contact Michael Anderson, who was one of Ruth Anderson's sons. He did so. He asked for Ruth Anderson's phone number, which Michael provided. And then Mr. Lip called Ruth Anderson and set up a time to come meet her. That's why this is a consumer approval transaction. It was a telephone solicitation. So she signed that agreement, paid a $500 deposit as indicated there. And then Anytime Restoration proceeded to literally strip the Andersons' home of virtually everything. I mentioned in my filings that they're literally camping in their own home, and that's not an exaggeration. They took towel bars, they took patio furniture that was outside of the home, nowhere near the fire. They took everything. They took utensils, they took cookware, they took, you name it, they took it, and they still have it. They're storing it, and they want to charge us $4,000 a month to store it. They've refused to give it back. So that's what Anytime Restoration knew as of March 27th. And if you look at that letter, Your Honor, at that point, I was under the impression that Minnesota law governed because paragraph 27 of the contract that Ms. Anderson signed says so. It says Minnesota law governs. I've since learned there's a Minnesota statute that applies that a contract like this, Wisconsin law will govern even if the contract says another state's law does. So on April 8th, 3 days before the complaint was filed, I wrote again. And at that point, I wasn't quite sure Wisconsin law applied. So I continued to cite Minnesota law, but I also cited the Wisconsin law that applied. And I said, even if Minnesota law doesn't apply, Wisconsin law applies. 3 days later, Anytime Restoration files their complaint. And in paragraph 7 of the complaint, they indicate that a member of the Anderson family contacted Anytime Restoration to inform it regarding the fire and the services that Anytime provided. That's wrong. And they knew that before they filed the complaint. And that's the primary issue here is, as Your Honor knows, Wisconsin law requires that an attorney conduct a reasonable investigation into the facts before filing the complaint. So 2 weeks before they filed the complaint, they were on notice that what they later alleged was not how this happened and that this is a consumer approval transaction and that it's void. Here's what should have happened. They knew that Daniel Lip was a former employee. They didn't even try to contact him. You'll see in his affidavit, no one from Anytime Restoration has contacted him. Wisconsin law, I assume we're going to hear that the attorney, Mr. Grecian, called his client, and this is what he was told by his client. You can only go by what your client says. Well, Wisconsin law provides that you can't just rely on what your client says, especially if it's not direct information, it's hearsay information. So here we have a client or an attorney who's relying on their client's story when the Andersons have made him aware before he filed the lawsuit that his version of the facts is wrong. They do nothing to investigate the claim. And then they go ahead and in response to our answer and counterclaims, they amend their complaint. And in the amended complaint, if you look at paragraphs 7 through 9 of the amended complaint, they virtually adopt our version of the facts. So I would argue that that is an implicit admission that what they originally pled, that they didn't know what was going on. They didn't know how these parties came together. And by basically adopting our version, that's implicit evidence and an admission that there was no reasonable inquiry made. Now, in response to this motion, they provide Your Honor with the declaration of a D.D. Holzenagel that they claim creates a fact issue about whether or not our version of the facts is correct. But if you read her declaration, Your Honor, it's hearsay upon hearsay. She claims that Daniel Lip in some marketing meeting told 5 employees at Anytime Fitness that the
Restoration.
sorry,
Yeah.
Anytime, I've been saying that
Yeah.
throughout.
Very similar.
Anytime, thank you for the correction. Anytime Restoration, that the version that they originally claimed was what happened. But if you read her declaration carefully, she wasn't at that meeting. She was talking to these employees, so this is hearsay. She said that she discussed it with these employees who are at the meeting. So my question is, if that's the case, where are these, and they reference them as current employees, Your Honor, where are these employees? Why didn't they submit declarations instead of Dee Dee Holznagel? Because her knowledge is hearsay. Here's the other thing that's not contained in her deposition. In John Campbell's affidavit, he talks about the fact that he got a $500 referral fee from Daniel Lip for letting him know about the fire. And he talks about that. Now, and he says that, or Daniel Lip talks about the fact that that's an anytime restoration policy. They pay people $500 referral fees. She doesn't deny that. She doesn't say that's not our policy. That's not wrong. So if you look at all of the evidence together, there is a complete lack of a reasonable inquiry. In fact, I would say that there was no inquiry into how this lawsuit began. It is clear from the undisputed facts and the facts that you can actually consider, because I would submit to you, Your Honor, you can't consider anything that's in Dee Dee Holznagel's affidavit. It's hearsay. The undisputed facts, and now the facts that Anytime Restoration has adopted in its amended complaint, clearly show this was a consumer approval transaction. And because it was a consumer approval transaction, that notice to cancel requirement needed to be in there. It wasn't. We canceled the agreement on March 27th, 2025. According to that same statute, the entire agreement is void, including any security interest that Anytime Restoration is claiming it has in any funds. The statute also says that Anytime Restoration is not entitled to any compensation, and that we're entitled to attorney's fees if we bring counterclaims, which we have, or asserted this as a defense, which we have. Now, there's a new attorney involved, and he'll speak in a moment, but he is now making the argument, as you saw in their response, that the insurance company should be somehow equitably stopped from not paying, or my client should be equitably stopped from not paying Anytime Restoration. And he cites a couple of cases to support that. Those cases are factually dissimilar. One of them, first of all, both cases talk about the fact that there were years of negotiation in those two cases between the parties in terms of, on the one hand, was there a settlement or wasn't in the affordable erecting case? In the other hand, was there coverage, insurance coverage or not? In the Nugent case, here there were not years of negotiations, there's months. This happened in September, and we started communicating in March of the following year. In the Nugent case, there was no argument that the underlying insurance policy was valid and enforceable. The only issue was that it expired. And then it was argument whether, because people behaved like it wasn't expired, should the insurance company be equitably stopped. The affordable erecting case is a very limited holding. If you read that case, the Supreme Court said that the estoppel applied in this case to a settlement agreement between the parties. And it was very clear to say, we find that estoppel applies to settlement agreements in this situation. This is not a settlement agreement. This is a contract that was void the moment my client signed it, for the reasons I've illustrated. So for that reason, and the fact that there was no inquiry as to how the parties came together, we're asking this court to, as a sanction against the law firm and the attorney who signed the pleadings, dismiss these claims against my client, all of them, award us our attorney's fees, and sanction the attorney who signed the pleadings and his law firm. Thank you, Your Honor.
Thank you. Mr. Edel, are you going to be arguing?
I will, Your Honor. And I appreciate Your Honor's attention to the matter and getting the order to appear remotely signed early this morning so that I could appear remotely. I do appreciate that very much. First and foremost, I think the most glaring issue with the defendant's motion here is that under 802.05, Wisconsin statute 802.05, when a sanctions motion is brought, it shall be brought as a motion for sanctions under this rule shall be made separately from other motions or requests and shall describe the specific conduct alleged. What the defendants are doing here is basically bringing a motion to dismiss, and seeking a dismissal is not proper under 802.05. There's no remedy under 802.05 allowing for dismissal. The only thing that can be awarded or determined by Your Honor in this court is whether or not to apply a directive or a non-monetary nature in order to pay a penalty into the court, or if imposed on a motion warranted, in order directing payment to the movement or to the movement. There's nowhere in 802.05 that allows for dismissal of the action. And one of the things that I cited in the responsive motion papers is that based on all of the Wisconsin case law, there must be an order of dismissal or a judgment or something along those lines that would tend to indicate that the factual dispute has been resolved or determined or otherwise dealt with. And by pursuing a motion, by seeking dismissal through this motion, they're avoiding like a very large procedural step, which allows for my client, the plaintiff here, to submit evidence on behalf of itself and contradict or stand behind or offer other evidence that would disprove these affidavits that have been submitted by Mr. Lip and the other witnesses that have provided their affidavits. As to Mr. Gaber's point or assertion that Ms. Holtznagel was not in attendance at that marketing meeting, that is not true. The reading of that affidavit or declaration is extremely narrow. She was at that marketing meeting. That's her firsthand knowledge. And so it's not hearsay upon hearsay. It's very much evidence that would allow for impeachment of Mr. Lip. And therefore, it's not hearsay and extremely reasonable for Mr. Grecian and myself to rely on that particular knowledge and information, as well as discussing with the other employees. Here's the other issue too, is that at this particular juncture, there hasn't been discovery and there hasn't been a coming forth of all of the evidence to defend against this. And there's numerous other Anytime employees that were present at that marketing meeting that can offer evidence to oppose these affidavits. And so there's a glaring fact issue as to whether or not what is said in those affidavits is true. And under the holding of Wind Point Restoration, Inc. versus Weichel, that pinpoint citation is 953 Northwest 2nd, 98. That stands for the proposition and understanding that if the defendants contacted Anytime first, that their assertion of this defense or this statutory defense does not apply. It's an exclusion, and therefore the fact issue is extremely germane to whether or not this statutory defense is even allowed in this case. Second, there is a large fact issue and a legal issue to be addressed here. And you can see that in my declaration, I provided a bunch of emails between myself and Mr. Gaber that talk about, hey, there's this very glaring issue with the defendant's signature of a policy holder release agreement between them and their insurer, UMIC. I said, I've done the research. I can see from this that there is a very good argument for equitable estoppel here, even if the emergency work authorization is deemed a consumer approval transaction. That being said, I believe that we should withdraw these motions and get into discovery and determine whether or not, and basically see whether or not there are there are evidentiary issues as I've described, but as it pertains to UMIC and their signature of that policyholder release agreement in accordance with the final approved pricing and coverage for this, I said, hey, look, there is legal support for this. There's factual support for this. What do you want to do? And basically, we're here before Your Honor on a motions for sanctions with no determination as to a motion to dismiss. I do believe it's very, very procedurally improper and premature to bring a motion for sanctions, especially at this time in litigation. And based on that, there are basically 802.05 turns and says, hey, look, when a defendant to this motion for sanction is required to respond and put forth its evidence, they can seek attorney's fees and the like. So in response to this, Anytime would request a award of attorney's fees against the defendants in this matter and their firm for an award for attorney's fees in responding to their motion for sanctions.
I see a few flaws in your argument. 802.05 definitely allows for a dismissal as a sanction. That is very, very clear. The court, granted, it is to be looked at the end of all other sanctions, but 802.05 definitely allows for a dismissal, especially if the court finds that this is frivolous or that other things were violated on behalf of or by the plaintiffs in filing the matter. So that's definitely incorrect. When I reviewed Ms. Hosnagel, Dee Hosnagel's affidavit, it is not clear. It does not state at all that she was in attendance at that meeting. She very clearly states that other employees were in attendance. She spoke with other employees. I read that very clearly in her affidavit, and I can pull it up right now, in which she discussed this matter with the current Anytime employees that were present. They recalled lip stating blah, blah, blah. She did not at any time say, as she stated in the very beginning, that a meeting was held by, in paragraph 5, Lip told the story during a marketing meeting at which numerous Anytime employees were present. I was present as well, would have been in there had she been present. That is not how the court reads and reviews that signed and sworn affidavit declaration from Ms. Holtznagel. Also, you're talking about the defendants in the argument of if the defendants contacted Anytime first, then the assertions wouldn't apply. as Attorney Gabor, as Attorney Gabor indicated that if you look at the initial summons and complaint that was filed, which the court did, it indicates in paragraph 7, just as Mr. Gabor stated, that shortly after the fire, a member of the Anderson family contacted Anytime to inform it about the fire and to inquire about the services Anytime provided. We know that's not true because then the complaint was amended, which indicated a family friend of the Andersons contacted Daniel Lipp. I'm not hearing or seeing that the defendants contacted Anytime at all. Response. I don't think I'm looking at this wrong.
No, so there is another member of the family. His name is cited throughout the email correspondence in my declaration. I believe, let me just get this certain.
Your Honor, that's Kyle Anderson. That's
Kyle.
another son
Thank
of
you.
Ruth Anderson. And he's here, by the way.
All right.
Thank you.
So I'm going to pull up
And-
your declaration.
And he's not in any of the declarations because he wasn't involved with the contact with Anytime Restoration. That was Michael Anderson.
Matthew.
I'm sorry.
Yeah.
Anytime Fitness
I
and
read
Michael.
it.
I'm going to
It's
rename your child. I'm sorry. Matthew Anderson.
I will try and pull up Mr. Edel's declaration, but I cannot find it. Yeah, Matthew, we have a declaration of Matthew Anderson, Mr. Lipp Campbell. Let's see. No, Matthew Lasner.
That's another attorney at my firm.
Thought I had them all pulled up. Let me just see. Yeah. Okay, I have your affidavit pulled up right now, Mr. Edel. And I'm not seeing Kyle Anderson.
He's referenced throughout the email correspondence attached as Exhibit C.
I'm seeing that he was just stated as we're going to get this to him. We haven't heard from him. But you'll admit though that Kyle Anderson is not the party, is not the individual who resided in the home that burnt up in the fire. That would be Ruth Anderson, correct?
That is correct, Your Honor. And
So Kyle Anderson is not a defendant, correct?
that is correct, but it would be my assertion that Kyle Anderson can act as an agent of the defendants by making certain outward
I'd love to hear
representation.
that argument. Love to hear that argument, because I'm going to tell you, I'm not having my son act as an agent for me unless I have a document that says he can act as my agent. Correct? So Anytime worked with Kyle, wanting to work with Kyle, but Kyle's not Ruth, correct?
Correct.
Okay. What else would you like me to hear and to know, Mr. Edel? Are you still on the case, Mr. Gleason?
I am not, Your Honor, but I'm happy to provide some comments since I've been implicated in it.
Yeah. Implicated how? Your name's in it. You were initially the attorney on the case. You are no longer, so it's been passed off. So your hands are clear.
Only to the extent, Your Honor, that he's asking for sanctions against me personally as well.
Oh, that's correct.
To
Yes,
that
'cause
extent,
you initially filed.
I would appreciate the
All
opportunity
right.
if Your Honor would.
Yes, I will. I'll allow that.
A few brief comments. I will not take up a lot of your time. First, to the extent that this motion is based on a factual assertion under 80205 to C, the rule requires that a motion to bring sanctions cannot be brought if that factual assertion is corrected within 21 days, which is what we
Safe
have,
harbor.
which is
Yeah.
what we have here.
Okay.
Right, so to the extent that this motion is based anything on a factual assertion that was corrected, and he only raised one factual assertion, that paragraph 7, the motion can't be granted, at least for that portion of the relief sought by the rule. And I presume that Mr. Gabor knew that rule and elected to go forward with this motion to begin with. As it relates to the other two prongs on 80205 that he's seeking this relief on, I've heard a lot of discussion about the underlying merits and final disposition of the case, which clearly is highly in dispute based on what we've heard from both sides. To argue that factual disagreements early on in a case or legal disagreements early on in a case suddenly bring rise to motions for sanctions, Your Honor, you'd be facing that in every single case. I will point out a few factual errors that Mr. Gabor made just this morning. First of all, he claimed that on March 27th, he sent a letter to me regarding the facts of this case. That's not true. That letter went to Mr. Humuth at my firm, and then I got involved in the case thereafter. He said that it was not until my discussions and communications with him where I raised the idea, hey, look, Minnesota law does not apply here. You're barking up the wrong tree. We have Wisconsin property, Wisconsin activities, Wisconsin individuals. This case belongs in Wisconsin, and the law that applies is Wisconsin. Thereafter, he continued to send letters and a filing seeking relief under Minnesota law. If the standard is submitting a filing to the court that's asking for the application of completely inapplicable law, if that's the standard, then we have to look at both sides here. And I think he ultimately admitted his complaint. I drafted a motion to dismiss saying, hey, you're bringing these claims under Minnesota law. That's not right. If you want to bring them under Wisconsin law, go right ahead. He amends the complaint. We withdraw a motion to dismiss because he fixed his pleading. That's the standard course here, not running to the judge as soon as there's a factual or potential legal dispute. That's why everybody's in law in front of the court, because there are factual and legal disputes that need to be resolved. A motion for sanctions on the front end is not the way to do that. And quite frankly, I think it's improper that we're here to begin with.
I didn't see that you filed a response in this case. I only saw Mr. Eddles. Did I miss something?
I submitted a letter. There was an issue because since I'm no longer a party or a representative, I couldn't file it through the normal course. So I submitted a letter. We had it ready to go.
The little one?
Yes, ma'am.
Oh, yeah, I read the little one.
Yeah.
I'm a paper person, if you can't tell.
Essentially, I have, I believe in Mr. Adele's arguments, and I didn't come here with the intention of hitting you with the exact same arguments, but more to be here because I am a part of this, to answer any questions you might have of me and to show that I take this seriously.
You were the initiating attorney.
Yes, Your Honor.
So, all right. So I didn't miss anything because it was just that short little letter from July 17th, correct?
Yes, I don't believe it got filed until the day after, but it was, we attempted to get it filed the day that it was.
Oh, I reviewed it. So that's all I wanted to know if that was the letter that we're talking about. Okay. So I have an understanding with regards to that. Anything else you would like to add, Mr. Grecian, Attorney Grecian?
Again, his statement that we were on notice before April 11th, that the complaint violated Wisconsin law, again, untrue.
And
He
you-
did not adopt Wisconsin law until on into May of this year. And so I would just ask your honor to be careful and double check the assertions by all the counsel here before you make a decision.
Thank you. You indicated that that Mr. Gabor did not send a letter on March 27th, 2025. What date are you indicating that he sent a
No,
letter?
he did send a letter, your honor, but the letter was to Mr. Helmuth
Oh.
at my office, not to me. He said he sent it to me. I wasn't involved in the case until after that point in time where I was brought in on the case. And it's a minor thing, I understand, but facts are important. And if we're arguing about facts and signing your name to things based on facts and making representations to the court based on facts, it's important to get the facts right.
Can you spell Mr. Helmuth's last name?
Hellmuth.
Oh, Helmuth?
Yes, ma'am.
Helmuth. Okay, all right, thank you. Rebuttal, Mr. Gabor?
Yes. It's true. The letter was addressed to David Helmuth. I misspoke. I didn't know Mr. Grecian existed at that time, but his assertion that they weren't on notice about Wisconsin law is just incorrect. If you look at my April 8th letter, 3 days before it was filed, I continue to cite Minnesota law, but I also say, well, look, even if that doesn't apply, here's the Wisconsin law that you're violating. And the fact that I thought that Minnesota law applied, I would argue was in good faith because the contract says it does. Okay, so after I did some additional research, I saw Wisconsin has a statute that basically voids that part of the contract, and then we pursued Wisconsin law. And I think it's important to note there is no factual dispute, Your Honor. And the facts are as we have laid them out, because number one, you see the affidavits that we've provided. Number two, when Mr. Grecian corrected, as you've seen, corrected the pleading, he adopted our version of the facts. And finally, there's no dispute, as you've indicated, because the declaration of Dee Dee Holznagel is hearsay. Mr. Adele represented things in that affidavit or declaration that simply aren't there. There is no dispute. There is no reason this case should go on any longer, and my clients should have to deal with this when they're literally still trying to put their home back together. So again, I would ask that and just a point of clarification with this whole Kyle Anderson thing. Okay, what I think Mr. Adele was talking about was he's talking about some release that was signed between Ruth Anderson and her insurance company. Well, that's a release between her and her insurance company. That has nothing to do with any time restoration. So this case should be dismissed respectfully, and my client should be awarded attorney's fees. And the attorney and Helmuth and Johnson should be sanctioned because, contrary to what Mr. Grecian is saying, they knew Wisconsin law applied. He just said it. He's telling me I was barking up the wrong tree. I should be pursuing Wisconsin law. If he knew that at the time, then he should have also known there's a Wisconsin statute on the books that precludes these type of contracts. And really, the situation we're in here today is the reason behind this law, where 2 days after a fire at someone's home, a company comes in when somebody is distressed and in a bad way, and they sign off on something. That's exactly why you have this 3-day right to cancel, that the language has to be in that contract. And this is a poster boy case for why that this law is in effect. So again, I'll just respectfully ask you to dismiss this case, sanction the attorneys and the law firm, and award my client's attorney's fees. Thank you.
All right, the only correction I would make to you, Mr. Gabor, is they should have known Mr. Grecian existed. He's the one who filed the original complaint. Clearly, he signed it electronically, but his name is right there.
Right, but on March 27th, he wasn't involved yet, like he indicated. It was Mr. Helmuth that I was dealing with. And right after that is when I started working with Mr. Grecian, who did sign the pleading.
All right, thank you.
Your Honor, may I have a
You can have a brief, yes.
I think one of the things that is important here is to understand two things. One, Anytime Restoration came out to the property under an agreement with the insurance company and the Andersons to do the work and actually did the work. And the check is sitting with the Andersons and has not been cashed and paid to Intertime. So I think that is a significant fact that has been glossed over here. They're sitting on a check of close to $200,000 based on an agreement between the Andersons and their insurance company and Anytime to come out and do the work that was actually done. That's the basis of this case to begin with. Whether there's some strict reading of some statute, which I will address shortly, that tries to get them out of that obligation to pay for work that was already done, that's what this dispute is about. But it's equally important to remember or to check into the differences between the Minnesota Home Solicitation Sales Act and the Wisconsin Consumer Approval Act. They are not the same. Mr. Gabor pointed out that under Minnesota law, a transaction that is initiated by a telephone conversation falls under the Home Solicitation Act. That is not the same under Wisconsin law. I don't have the statute in front of me, but I believe that the requirement under Wisconsin law is if the contract is initiated by face-to-face communications between the consumer and the contractor, then it might apply. That's not the facts that we have here.
Your Honor, that's just wrong. And that just is a perfect example of this whole case. There's no preparation, there's no inquiry, there's nothing. I read the statute in open court a moment ago. Initiated by a face-to-face solicitation away from a regular place of business of the merchant or by mail or telephone solicitation directed to the particular customer. I mean, this is not only are there factual misrepresentations, you just heard a legal one. I mean, this is why we're here, Your Honor, is whether it's Mr. Grecian, Mr. Adele, Helmuth and Johnson, there's nothing just wrong about everything. And this case shouldn't be here. This case should be dismissed.
All right, thank you.
Oh, Your Honor, one more thing, and I apologize, this wasn't in my motion, but Anytime Restoration still has all of Mrs. Anderson's belongings. And if you find that this statute applies, they were supposed to return that, her belongings, months ago. She's still literally camping in her own home. So maybe as an additional sanction, and I know this wasn't in my motion papers, is maybe you can order Anytime Restoration to immediately return her personal belongings. And as to the work being done, we don't know what work's been done. We only have Mr. Grecian's word that any work has been done. Thank you.
Generally, I will say that you can't add something last minute because
Fair
you
enough.
put the other parties on notice. However, with 80205, that would fall under a sanction where the court can then order that. So the notice requirement wouldn't necessarily be applicable. With hearing the last statements made by Mr. Gabor, either Mr. Edel or Mr. Grecian, would you like to make any other statements?
Would like to
only
make
have a clerical thing.
You don't
I
have
have
any
a-
others?
Not for me, Your Honor, just a clerical thing to address at the end if we.
Well, just address the clerical thing, then I'll go to Mr. Edel.
Since I am no longer on the case, I'm not receiving filings. I just want to make sure that I do what I need to do on my end to get notice of whatever Your Honor decides in a timely manner. So if there's something that I need to do as far as with your clerk, I'll be happy to do
I
that.
think we have your address, we have your information. We can, I don't think we can we add him as an interested party?
I think so, yeah.
We'll add you as an interested
Thank you,
party.
Your Honor.
All right, Mr. Edel.
Yes, thank you, Your Honor. I have brought this up with Mr. Gabor as well, that the issuance of insurance proceeds from UMIC to the defendants in this case is predicated and based on the work to be completed and that was completed by Anytime Restoration. And I told Mr. Gabor that, look, I know that UMIC has issued this check to your clients. If this contract is voided or canceled, as you say, under this statute, then the insurance proceeds that are outstanding and issued to jointly both Anytime Restoration and the client and his clients, the defendants, is outstanding, and his client's retention of those funds is improper without UMIC being on notice. And getting them involved was what I discussed with Mr. Gabor and said, look, I don't know what to, this is something outstanding that we need to resolve here. But your client's retention of these funds when Anytime Restoration is a named party on the check issued by UMIC is not proper. And this is where the argument for equitable estoppel very much comes into play here.
I completely understand where you're going with that and with the argument of equitable estoppel. Anything further, Mr. Edel?
Nothing further, Your Honor.
I'm going to guess that the parties have not, outside of filing these motions, you've not done anything else, any type of negotiations, no mediation, nothing of that nature?
No, we
You did,
made a settlement offer and we were flatly refused.
but no mediation.
No mediation.
Because I'm going to tell you, I've read it all. I've read everything, even the motions, partial motions to dismiss and then the withdrawal. And I've heard arguments here today, and it did kind of tie up some things in my legal mind. But I'd like to see the parties go to mediation, because I'm going to tell you, I don't know if either side is going to be happy. So you might be able to reach a better resolution if you go to mediation. I have 90 days to reach a decision, a written decision, and that's what I'm doing. I'm staying on a decision here today. And I'm going to see if you can give mediation a shot. And if you don't, I'm fully prepared to get my decision out very quickly, because I think there are a lot of outstanding issues here. Both sides have some strong arguments on some of the points. And this is a case, as you all have indicated, that we have first Minnesota company, Minnesota contract. However, we do have the Wisconsin Consumer Act at play. We have people's lives at play. We have Ms. Anderson's, as you said, her life, her things are being stored somewhere. Anytime Fitness, they have made some good points. I see some flaws, but I think that I would at least like to attempt mediation. Otherwise, I am fully prepared to do a decision, and I can do a decision after getting whether or not an agreement was reached in mediation. I can get a decision out within a week, 2 tops.
Okay.
May I inquire to the court about something quickly?
Yes, Mr. Edel.
Pending, so I know you have 3 months to get a decision out. And I've brought up the issue that this is kind of couched as a motion to dismiss. Are the parties to engage in further discovery? What are we supposed to do? No?
I don't believe this is a motion to dismiss. I believe he's asking for the harshest sanctions, which is within the court's authority to do. If I find that Anytime Restoration has not done things correctly, or if this is frivolous, or there are some misrepresentations, the court in its own power can dismiss the matter.
Okay.
So I don't believe it's couched as a motion to dismiss. So I want to see mediation. Can it take place within 45 days?
Possibly have to pick a mediator and work with their schedule.
Well, I have great mediators here.
Okay.
Unless you wish to choose a mutual mediator that you both can agree upon.
Maybe we can try that first.
I have a former court commissioner that I use. I have my predecessor judge that I use. I have another predecessor judge in another county that's really good, that they handle these mediations very well, and they thoroughly know the law.
Okay. Well, maybe it would be good, and I know we're all here now, a predecessor Wisconsin judge who knows Wisconsin law might be the perfect choice as a mediator.
Mr. Edel, what do you think?
Agreeable to that.
And it's an in-person, I don't allow Zoom mediation. You get more done if you're in person.
Fair enough. We're
And,
here.
Ms. Anderson is obviously going to need to be present, and there will need to be a rep at least reachable on a dime by the telephone for Anytime Fitness. Not necessarily going to say that they need to have a party there, but it could be to their detriment if there is not a representative there. But as long as they are easily accessible by telephone, any objection to that, Mr. Gabor?
No.
So within 45 days, mediation, I will have my assistant reach out to the two retired judges that are in mind, and or the retired, or not, he's a retired commissioner, but he's still a practicing attorney, very knowledgeable on all of these types of issues. I will have her reach out and then contact both sides.
Thank you, Your Honor.
All right. You're going to be a part of this too, right, Mr. Grecian?
Part of the mediation?
Yes.
Well, I don't have any dollars in my pocket, one way or the other, but I will be
Well,
involved
You have the sanction.
as
Potential.
much as I need to be. I will be involved.
Okay. All right. Anything further?
No, Your Honor.
Then
Nothing
we are
further.
adjourned. Thank